All right, everybody, we're going to go ahead and get started. Thank you for coming here today. I know it's not our normal time, but we're glad that some of you made it out today. We're very excited to have Professor Blackman here from the South Texas College of Law at Houston. He is an eminent scholar in constitutional law in the United States Supreme Court. I'm sure a lot of you have watched his videos for your 1L classes. So without further ado, Professor Blackman.
Thank you so much. Thank you. Happy to be in Gainesville. I've not been here about a decade, so it's good to be back. The topic today is the Second Amendment. Now, when I went to law school, the Second Amendment wasn't really a thing. The Supreme Court had really no cases on the doctrine, and people thought, no, this is kind of a scholarly curiosity, but had no practical effect on constitutional law. 15 years later, it's having a fairly significant impact on the law, though perhaps not always in the direction I might like. So let's walk through the cases. The Supreme Court's first major case involving the Second Amendment in the modern era was Heller, D.C. v. Heller. And the question in that case is whether the Second Amendment guarantees a right to bear arms that's connected to militia service or an individual right. This case only involved the District of Columbia. D.C. had banned possession of handguns by virtually anyone in the district unless you had some sort of very good use or justification. Dick Heller worked for the government. His job was to guard federal judges. So he was given a gun at work, carried on all day defending people, and then when his shift finished, he had to put his gun in a locker and leave it at the office, so he couldn't even defend himself. So he brought a lawsuit on behalf of himself, and there was several other people. Heller was kind of unique in that he applied for a permit. He actually went to City Hall and said, I'd like a gun permit. They're like, we don't give gun permits. Like, okay, fine. That's what we call standing. And that's how he was able to bring his case. He applied for a permit that he could not get. When the case was first filed, the Supreme Court looked a little bit different. Justice Sandra Day O'Connor was in the court, as was Chief Justice Rehnquist. But by the time the case trickled up, O'Connor was gone and he was replaced by Justice Samuel Alito. Heller was decided in 2008 and the court split 5-4. Justice Scalia wrote the majority opinion in Heller. And the court had two primary holdings. First, the court held that the Second Amendment protects an individual right to keep and bear arms. This right was not connected to militia service. Scalia looked at the text of the Second Amendment, provides a well-regulated militia being necessary to the security of a free state. The right of people to keep bear arms shall not be infringed. He said, well, this first part about this militia being regulated, that's separate from the second part, which is about the right. Now, in this part, the court split 5-4. Justice Stevens and also Justice Breyer wrote very, very vigorous dissents. They said, this is nonsense. This is elevating a fiction over the actual text, that the Second Amendment is restrained by this prefatory clause about the militia. But the second part of Heller cast somewhat of a limitation on it. Justice Scalia said, well, yes, we're recognizing this right, but these rights are not absolute. The court didn't actually decide what kind of scrutiny should be used to review gun claims. They said, well, it's not rational basis. We won't really tell you what it is. And that was a function of not having enough votes to apply strict scrutiny. There just weren't the votes for it at the time. There was also this paragraph in Heller, which has kind of become the only one everyone wants to talk about. And it says, we do not here cast doubt on long-standing regulations. And the government can disarm people, dangerous people, right? Criminals. And the court adds, dangerous and unusual weapons, those can be banned as well. So you have this very robust discussion about how history informs the meaning of the Second Amendment. We had this one paragraph that was just sort of made up and said, well, by the way, if there's a law that's been in books for a long time, it's probably okay. And if there's some dangerous, unusual weapons, you can ban those. And for felons and some other people, yeah, you can disarm them without any justification at all. So as much as Heller was sort of a success for originalism, this one paragraph sort of undermined it. And wouldn't you know it, in the days, weeks, months, and years following Heller, that's all anyone wanted to talk about, the limiting paragraph. Okay. So immediately after Heller was decided, we get the second round of litigation, the case called McDonald v. City of Chicago. Heller only concerned the Second Amendment as applied to the federal government. But that didn't answer the question of incorporation. That is, does the Second Amendment also restrict the state's power? This case goes to the lower courts in Chicago, says, no, fine, you might have a federal right to bear arms in DC, but nowhere else in the country, that's it. The lower courts actually agreed and refused to incorporate the Second Amendment. Case goes to the Supreme Court. Again, the Supreme Court reverses by a 5-4 vote to say that yes, the Second Amendment is incorporated. But the justices fractured on the rationale. There was a 4-member plurality by Justice Alito that said, aha, we will use the due process clause of the 14th Amendment to incorporate. That is, the right to bear arms is liberty, and the states can't deprive you of liberty. Boom, boom, boom. Substantive due process, incorporation. That is how much of the Bill of Rights have been incorporated from the prior century or so. Justice Thomas wrote the controlling fifth opinion, the fifth vote, and he said, no, we don't want to use substantive due process. We want to use what's called the Privileges or Immunities Clause, and this is actually, I think, correct, that this is the basis of where all these substantive rights come from, the PRI clause. Justice Scalia did not join Justice Thomas. He said, well, Thomas, that's nice, but we're going to do this due process thing. Even I'm willing to go for it. So a bit of a cave by Scalia to substantive due process. So you might think at this point that the court's liberals say, okay, well, you know what? We lost in Heller, but we should incorporate like everything else in the Bill of Rights. But no, the 4 dissenters in that case said, no, Heller's wrong, and we won't incorporate it. Okay, so that was 2010. At the time, gun rights advocates, I'm one of them, we were excited. We were like, okay, this is awesome. We got McDonald, we got Heller, back to back, 2 years apart. The Supreme Court's going to answer all these really tough questions. For example, is there a right to have an AR-15? Is there a right to conceal carry? What about a non-violent offender? Someone with food stamp fraud, right? Can he be disarmed for life? There are all these very, salient issues about gun rights that were like, okay, we're going to get all these questions resolved. But that didn't happen. So 2010, 2011, 2012, 2013, 14, all the lower courts were upholding every single gun control law. It was very rare that any gun law was declared unconstitutional. Certainly the Supreme Court would take one of these cases, right, just to clarify the law. 2013, 2014, 15, deny. The court was not taking any cases. And at the time, people started getting a little bit, suspicious. Look, we have this new thing, the Second Amendment. Wouldn't it be nice for the Supreme Court to sort of clarify what this thing means? But all they did was deny. And starting in 2014, 2015, Justice Thomas began to dissent from the denial certiorari, saying, look, we need to take cases by guidance to the lower courts. We cannot let the lower courts run amok. Because by that point, all the courts were saying is, well, we will apply what they call heightened scrutiny. And under this heightened scrutiny, the burden was placed on the gun owner to show why he needed the gun. Let me tell you something. In constitutional litigation, whichever party has the burden is going to lose. If you're litigating a common law case, you want the other side to have the burden. Give the burden to the government, because that's going to mean they're going to lose. But all these courts were putting the burden on individuals to say, here's why I want to exercise my right. And that's just not how rights work. Rights don't put the burden on those who have it. It's on the burden of the government to justify it. But Justice Thomas was alone. And then soon enough, Justice Scalia started to dissent, saying, what's going on? We have this Heller thing. Why aren't you granting any cases? And in hindsight, it was probably because Justice Kennedy and probably Chief Justice Roberts didn't want to take a gun case. They probably knew that if they took a gun case, the Second Amendment would lose. And they were content to just let the lower courts figure this out and ignore the issue. Justice Thomas was furious. He said, this is not a second-class right. It's the Bill of Rights, right there with speech, right there with religion. It's right there up front. Deny. And then in 2016, February of 2016, as we all know, Justice Scalia passed away. It was a very sad day. I don't know if you remember it. It was at least a sad day for me. And one of the things that I worried about is, well, if Scalia's gone and Hillary Clinton wins the election and appoints, I don't know, to the Supreme Court, someone, that probably means the Second Amendment will not go further than it's already gone. That might be the end of it. In fact, There were some law professors, Chemerinsky and others, saying, well, we could reverse Heller, right? Get rid of it. So whatever little sort of marginal victory you might have had for like 5 minutes might be wiped away. Right? But then, Trump won. No one expected it. He won. He pulled it out. And the Republicans actually kept the seat open for an entire year. And one of Trump's first actions in office was to nominate Merrick Garland to the U.S. Supreme Court. Oh, God forbid. Neil Gorsuch. Well, where's my brain? To appoint Neil Gorsuch to the U.S. Supreme Court. Sorry, Merrick. He's like the Susan Lucci of the Supreme Court. Always nominated, never gets through. Gorsuch, there it is. Gorsuch was confirmed to the U.S. Supreme Court. And it's like, okay, now we'll get a Second Amendment case, right? And we didn't get it. And then with the next year, in 2018, Justice Kennedy announces retirement. We have Justice Kavanaugh. Okay, finally, we will get a gun case now. In fact, we got one. That's okay, finally, because Kavanaugh, for all of his warts, was very good on the Second Amendment in the lower courts. He was actually very strong on this. He had an opinion about the right to have ARs and other weapons. So he was good on this issue, at least in the lower courts. So the first case involved the New York City law. So New York had this very weird law. It said if you wanted to bring your gun to a shooting range, you had to keep the gun locked in a box in your trunk. And you had to have a permit to keep the gun locked in a box in your trunk, just to go to a shooting range. There's no justification for this law at all. None. Yet New York defended it in the lower courts. They won in the district court. They won in the Second Circuit. But then what happens when it got to the Supreme Court and they granted review? New York said, wait a minute, we don't want this law anymore. You ready for this? New York City repealed the law to moot the case out. And then New York State, the state legislature, passed a law preempting this law, saying, New York City, you can never reenact this law. They basically salted the earth. They got rid of this case, and they said, Supreme Court, please don't decide this case. It's moot. Right. So this is trying to frustrate the court's jurisdiction, right? The Supreme Court grants cert on a case, and New York does everything they're possible to get rid of it. And the court did find that it was moot, and they dismissed the case. There were a couple of dissents saying it's not moot, but it probably was moot. But without question, New York was trying to manipulate the court's jurisdiction, which is not a good thing. Okay, what happens next? Shortly thereafter, there's another case involving the right to carry. Many states have what's called a may issue regime. What does may issue mean? Well, if you apply for a carry license, maybe you'll get it, maybe you won't. It's discretionary, right? When I say discretionary, it means absolutely discretionary. It's based on, does the sheriff like you? Are you popular? Do the local politicos think you're important? It's not enough to say I need a gun for self-defense. Anyone can say that. You have to have a special need or a special justification. So New York was one of the about 20-odd states that had these sorts of may issue regimes, and it was challenged. Again, the lower court upheld it. The Second Circuit upheld it. It gets the Supreme Court. This time, New York is not going to repeal their law. They couldn't do this to them twice. That'd be a bit too brash. So they defend the law in a case called New York State Rifle and Pistol Association versus Bruin, B-R-U-E-N, Bruin. And this involved two guys who lived in upstate New York. They were law-abiding citizens, had no criminal history, and they wanted to be able to carry a handgun as they went to and from work. They lived in not the best neighborhood. They wanted protection. Again, the lower courts upheld this. Case goes to the Supreme Court. The Supreme Court rules in favor of Bruin. Justice Thomas wrote the majority opinion. Again, just keep flashing back. Justice Thomas was the guy who'd been dissenting for like all these years, saying, why don't we take a gun case? So finally, he gets a gun case he can decide. Now, this case was decided in June of 22, during the most chaotic 72 hours in the modern history of the Supreme Court. What happens? Dobbs overruling Roe v. Wade. Kennedy overruling the Lemon Test. And Bruin on the Second Amendment. These are the three most consequential back-to-back cases by the Supreme Court in my lifetime. All decided after an assassination attempt on Justice Kavanaugh and the leak of the Dobbs opinion. This was a very tumultuous period. It's even able to sort of think back upon it. But Justice Thomas's opinion was historical from top to bottom. Notice I didn't say originalist. I said historical, because there's a difference here. Justice Thomas said that the way to determine whether a particular gun control law is constitutional is we find analogs, similar laws in the past that could serve as a basis for this current law. Now, just to be clear, if you're an originalist, we ask, what is the meaning of the text, right? What does right to keep and bear arms mean? What is the power of the state? We don't focus so much on the types of laws that existed because those laws might have been unconstitutional. Maybe those laws were an exercise in discretion. Maybe they choose just not to regulate something. But Justice Thomas, to get 5 votes, I think, focused very much on practice. And Justice Thomas did a survey of almost 1,000 years of law. And he said that there's no analogy, there's no historical basis of prohibiting firearms unless you can show good cause, right? There were laws disarming people who committed crimes. Perhaps if you pose a threat to someone else, you might have to post a bond, what's called a surety. But there's no history of the state saying, okay, you can only carry a gun if you show you have good cause, a good justification. And because there wasn't any sort of historical practice to support this law, it was unconstitutional. Now, Justice Thomas looked, I think I said, at almost 1,000 years of history. He actually went beyond the ratification of the Second Amendment in 1791 to look at laws from the 1800s. This kind of annoyed Justice Barrett, the newest member of the court at the time. And Justice Barrett said, wait a minute, if we're originals here, why are we looking at laws from the 1860s and 1880s? It's 100 years after ratification. And what Justice Thomas said is, well, these laws are useful to show a continuous practice. There was a continuous tradition of letting people carry guns. What was unique, though, is that the New York law at issue was called the Sullivan Law, was enacted in the early 1900s. By the way, it was enacted to disarm Irish immigrants. That's why we have this law in New York. But the dissenters said, wait a minute, it's a 100-year-old law. Isn't that a good enough tradition for us? Thomas said, no, that's not old enough. Let's go back further. So this approach to the court of text, history, and tradition, I think, was unsettled from the start. Justice Kavanaugh and Chief Justice Roberts concurred in Bruin. They said, well, we agree with the majority, but here are some things we're questioning. You know, we reaffirm Heller that long-standing prohibitions are valid. The Sullivan Law is 100 years old. That was pretty long-standing. And they say people who are dangerous cannot have guns. And Kavanaugh added, if you can't pass a mental health check, you can be denied a gun. Why would he mention that? If you recall, a person just tried to shoot him who had some mental health issues. I think Kavanaugh's projecting just a little bit. Look, these justices are real people, and they go through some crazy stuff, and it affects their opinions. So what happens next? Bruin is decided in June of 2022. Almost immediately after Bruin's decided, another case comes on the radar. The case of Zaki Rahimi, Rahimi. Rahimi. Rahimi is not a good dude, as we would say. He was abusive to his girlfriend. He shot lots of people. He shot up a burger joint, a Whataburger. He shot in the car. He actually didn't hit anyone, which I still can't understand. He shot lots of people, didn't hit anyone. Amazingly, he was not actually arrested for shooting people. I don't understand why. If I figure it out, I have no clue. But what did happen is that his girlfriend saw what was called a DVRO. DVRO, that stands for Domestic Violence Restraining Order, a DVRO. What's a DVRO? It says that so-and-so cannot come within so many feet of this woman. You must keep your distance. Okay. Again, he should have been arrested for battery, among other things, but he wasn't. I have no objection to the DVRO in the abstract. But as a consequence of having this order, it triggers a federal disqualification. Under Section 922G of the U.S. Code, if you are subject to a DVRO, you are considered a disqualified person. That is, you cannot possess a firearm. Shockingly, Mr. Rahimi kept his gun. This is a bad dude. And he was arrested and charged by the feds. Again, not by the states for shooting people. He was charged by the feds for possession of a disqualified person because he had a DVRO against him. He had not been convicted of a felony. He simply had this restraining order issued against him, which those can actually be issued ex parte, without any sort of process at all. We'll talk about the due process maybe a little bit later. So initially, the district court found him guilty. He was sentenced to time in prison. While the case was on appeal, Bruin was decided. It was sent back down for reconsideration. The Fifth Circuit, my beloved Fifth Circuit, rules that the Second Amendment does not allow Rahimi to be disarmed. And the argument goes like this. If you're convicted of a felony, to be sure, you can be disarmed, right? There's a long-standing tradition, thank you, there's a long-standing tradition of felons being disarmed. But Rahimi had not been convicted of a felony. And the court said there's no historical tradition of taking someone's guns rights away merely because they're accused of a crime or there's some sort of ex parte civil order put out against them. I think that the Fifth Circuit got this case correct, or at least correct in the sense of following Bruin as a precedent, right? Lower court judges have a job. They must follow Supreme Court precedent. Whether it leads to a good result or a bad result, they have to follow it. And I think the Fifth Circuit followed it faithfully. But what happened? The case goes to the Supreme Court, and the court splits by a vote of 8-1. Was not even remotely close. Who was the one in dissent? It was Justice Thomas. He's never found a gun case he didn't like. Justice Thomas was the lone dissenter. And you can just predict from the oral argument, this case is going to go off the rails, right? The question was not, do we overrule Bruin? That wasn't the question presented. The question is, how do we tweak Bruin, right? In other words, we have a precedent. We're going to make fun of the lower court for messing this precedent up. Meanwhile, we're going to change the precedent. So I'll say this again. I think the Fifth Circuit faithfully applied the precedent and the Supreme Court changed it. If you look at the oral argument, Justice Kagan is saying, you know what? We need some guidance. How do we give guidance to lower courts? Well, isn't Bruin the guidance? Isn't that the test? So what happened here? Chief Justice Roberts writes the majority opinion. And I have a love-hate relationship with the Chief Justice. I love him at times and hate him at times. But he's a good writer most of the time. Usually he writes in a very clear fashion, very direct, you know exactly what he's thinking, except when he's trying to cover stuff up. Like a magician, like misdirection. John Roberts is a magician. He's like, look over here, but he's doing all the stuff over here, right? He's like, just look over there. Look at the fancy bunny rabbit, right? This is where it's going on. So he basically says, we are not changing the standard in Bruin, but we're just going to clarify how this has to be applied. When you're clarifying something, that means you're changing it. And let me just walk you through what this means. Roberts said that we're applying a text and history approach, but text and history is not trapped in amber. Think like the mosquito from Jurassic Park, right? It's not trapped in amber. And here's what Roberts did. He's very creative. He's very crafty. There were two relevant historical practices that inform this decision, right? Number one, we know for sure that if you were a felon, you can be disarmed. No one's going to argue with that one. In fact, to be candid, you learned about this in criminal law. At common law, what was the only punishment for a felony? Death. So there weren't many felons running around. Generally, if you were a felon, you were executed. So it would not surprise me that, yes, when you were a felon, there were people saying, oh, I have gun rights. No, you're dead, right? You're at the end of a noose, right? So it's correct that if the state can execute you for a felony, then perhaps have the lesser power to also take away your gun and other rights. Okay, fine. In fact, one of the other elements is voting. That if you were a felon, you could not vote as well. So there are rights that are taken away from you, apparently both civil and political. But there's another category of laws that were relevant called surety laws. Surety, that's S-U-R-E-T-Y, surety. Okay, what's a surety law? A surety is a bond. You may see these in commercial paper in other classes, right? How'd this work? So let's say there's a really sketchy person comes to town and someone says, okay, I heard this guy cause some trouble in this other place, and I don't know who this guy is, and he's walking around with a gun. So the court might say, fine, if you want to keep your gun, here's what you have to do. You have to pay a bond to the court, and you have to have some character witness to vouch for you. If you do that, you get to keep your gun. And if for whatever reason you use your gun to hurt someone, you surrender the bond to compensate the victims. We didn't have a tort system like we do today. So this is a basic way of having insurance, right? This is a way of putting money in the court in advance and using it to compensate potential victims. It's not clear how often this law is ever actually enforced, and I think people make a lot of big deal about this, but we have these surety laws. So again, if you're a felon, ex post, you can be disarmed, and ex ante, that is in advance, you could be required to post a bond, you get to keep your gun. And Robert says, okay, that's good enough for me. We'll put them together, right? So ex ante surety glommed together with ex post disarmament for felons. That's good enough to take a gun away from Mr. Rahimi. You see what he did, right? He took together two different historical buckets and combined them when that didn't exist. There is no historical precedent for the law at issue in Rahimi. It doesn't exist. Roberts just made one up. He just fashioned together the bunny rabbit with the girl in the box, and you weren't looking, and just put it together, poof, everything looks great, right? He's a magician. He's Houdini. He's a master. But don't fall for it. Never fall for it. When the chief is writing like this in a common law case, always look a little more carefully. So what happens? Justice Thomas is like, what happened? Only 2 years earlier, you were all with me, saying we need to find an analogy. Bruin considered the surety laws and said, no, these surety laws are not good enough. Right? It's not like this evidence came out of the blue. This existed 2 years earlier. We knew about these laws. And Thomas is like, what happened? What happened? There is no historical precedent for this. If you want to change the Supreme Court precedent, I guess you can do that, but you have to admit it. So then what happens? Thomas is like, you guys gutted Bruin. And it's not hard to figure out what's going on. I think the court in Bruin was a very fragmented place. And they said, okay, fine, Clarence, do whatever you want. We'll go along with you. Yes, it's ridiculous you can't carry a gun outside the home. Keeping bare arms to bare arms, right? Whatever you want, Clarence. But when it actually came push to shove, and you had not law-abiding citizens from upstate New York, but a guy shooting up burger joints, like, whoa, that's too much for us. We can't do that. No, that we don't want these people in our neighborhood, right? These people with these orders, right? So we'll let the good people have guns, and then this bad dude, okay, he's going to go away, right? We just let him go to jail. We don't need him to have a gun. That's fine. We don't want domestic abusers. Brett Kavanaugh does not want domestic abusers having guns, right? That we can't entertain that. So the court sort of modified its precedent. But in doing so, they weren't just deciding this case. They sent a signal to the lower court, JK, right? Bruin, we got it, but we didn't really mean it, right? Just kidding, right? You can apply this very fluid test where you sort of merge together these various historical practices, and that is sufficient. That is enough to get you to this result. So Mr. Rahimi's in jail still. He's not getting out. Curiously, the case went back down to the Fifth Circuit. And the Fifth Circuit panel basically said, okay, Rahimi, you go to jail. You stay in jail. But by the way, Supreme Court, you guys changed the precedent. The lower court acknowledged that the precedent was changed. So whenever you see, oh, Fifth Circuit reversed, that's a little bit unfair. Because Fifth Circuit applied the precedent as it existed. You cannot charge judges with the duty of clairvoyance. They can't predict what will happen in the future, even if we as analysts understand it. So what's left? We still have a number of other cases that are pending in the Second Amendment pipeline, one of which involves non-violent felons. And the classic example is Martha Stewart, right? Do we still know who Martha Stewart is? I hope so. Doilies, right? Can Martha Stewart have a gun? She was convicted of obstruction, insider trading, non-violent white-collar offenses. Why should a person convicted of a non-violent white-collar offense be disarmed? There's not really a good reason. There's no precedent for it. In fact, Justice Barrett, when she was on the Seventh Circuit for 15 minutes, had a case called Cantor versus United States and involved a guy who had been convicted of either Medicare or Medicaid fraud. I don't remember which one it was. He was selling these like insoles for shoes, and there was some sort of fraud, whatever it was. Not important. Why should he be denied a right to bear arms? Curiously, Trump pardoned him. I never quite figured out how that came about, but Trump pardoned the guy that got his gun rights violated, which would restore his gun rights. There's another case pending right now in the Third Circuit en banc called Range, R-A-N-G-E, Range. And what is Range? Food stamp fraud. This is a guy who lied on a food stamp application as income. That's a felony. Did you know that? If you lie to get more food stamps, you've committed a felony. Congratulations. You lose your gun rights the rest of your life. I don't know anyone who would think that's a just result, right? You've shown no danger to other. You were trying to get more government benefits because you were hungry or something, and you lose your gun rights. So Range might get to the court, and the court will say, oh, that's wonderful. Look, yeah, Rahimi shooting up a burger joint. No, you don't get your gun. Oh, Mr. Range, food stamp fraud, you get your gun. So I think that's another area. One other aspect of Bruin is where can you carry? Bruin reaffirmed this notion of so-called sensitive places. That is places where we can have gun restrictions. And it mentioned, for example, schools and courts, but it left a lot of other issues open. So one issue is college campuses, right? Can you ban carry on college campus? And so we don't have campus carry here, okay? Another issue is parks and any sort of public park. What about, this one actually comes to a curious relationship, houses of worship. New York basically banned carrying houses of worship, even if the priest or the rabbi wants it. If that is that a bridge too far. So a lot of cases pending about carrying in various public places. The other issue lurking in the horizon is so-called assault weapons, which is a term that really has no meaning. It means looks scary, right? But weapons with certain types of features that are big, right? The AR-15 is a classic example. There are about a couple states and maybe about a dozen or so jurisdictions within states that has tried to ban various types of assault weapons that they call. Judge Kavanaugh, when he was in the lower court, said that violates the Second Amendment. I don't know where Justice Barrett is in this issue, and I don't know who the Chief Justice is. I think the court will keep denying cases for all they don't want to decide this issue. One of the rubs is in all these jurisdictions, they don't actually ban the assault weapons. They say, okay, you have to register what you got, and you can't buy new ones. So if you're young and you haven't gotten one yet, too bad. You're out of luck. And eventually they go around to confiscating the old ones, right? Whenever, in the history of the world, the first step of confiscations, registrations happen over and over again. So when they've registered who has what, they will be confiscated. All right. The last point I want to address, and I'll pause to take some questions from the students, is the court is sort of fragmented on originalism. And we have this beautiful symposium scheduled starting, what, about an hour or so, on text, history, and tradition. And I think even among the court's originalists, they don't agree, right? They don't agree. And we saw this in Rahimi with two concurrences by Justice Barrett on the one hand and by Justice Kavanaugh on the second hand. Justice Barrett seems to be the purest of them all. She says we should focus only on the meaning of the Second Amendment, and we should stop in 1791 when the Second Amendment was ratified. We shouldn't look beyond ratification. The meaning was the meaning, whatever that means, that's what we have to recover. Justice Kavanaugh is interested in, no, that's not enough. He's obsessed with tradition. He's fixated on tradition. Tradition. He loves tradition. He likes looking to see what happened after ratification. How did the people interpret this? And he uses that as a way to indicate meaning. And Barrett's like, what are you talking about? That's not how we determine meaning. Who cares what happened years later, right? So those two don't agree. Justice Gorsuch didn't weigh in this debate. I'd say he's probably closer to Justice Thomas. Justice Thomas would take a far more rigid view and say, you need an actual analog. We can't just sort of look at this gestalt of all the things that happened and determine if that's enough. I don't know how the court shakes out on assault weapons. I'm not sure. And I'm not sure how they shake out on bans in various types of sensitive places. I think the court will do what they did for almost 13 years and just deny everything, hope it goes away. What that ends up happening is it basically delegates the lower courts the power to decide what the Second Amendment means. And I don't think that's any sort of a positive way to do business. Okay. All right. That's all I have. Thank you so much, and I welcome your questions. Yeah.
So, as a general matter, do you think that the possession of a firearm by convicted felon cases, do you think that this case is really going to change the outcome of those cases? Like, is this a situation where now because they've said, oh, well, these domestic violence restraining orders, so obviously we can take it from nonviolent convicted felons, or do you think they're still playing this loose there, or the court may try to find another way? I mean, sort of the bad guy stays in jail test, like this white collar felon from 30 years ago, maybe we don't want to keep them from always having a gun.
Right. So when Barrett was in the Seventh Circuit, she wrote about this exact issue, and she basically said, there's no tradition of disarming felons who are nonviolent. Right. And she's correct about this. But if you want to think about it, historically, felonies were violent crimes by definition. Were there many nonviolent felons back in the day? No. Right? I mean, again, if you were a felon, you'd be executed. So I don't know how far that line goes. I think the correct line is one that Justice Thomas drew, saying there's no practice, right, of disarming people without a conviction. But I think what the court would probably say is, Heller said that you can disarm people who are dangerous, and Mr. Range, who had his food stamp fraud, is not dangerous. That's enough. It's not going to be a very strong opinion. There's also the issue of due process, which I sort of just tabled over, and it's not entirely clear that a person who commits a very minor offense loses a civil right for the rest of their life. That might actually be a due process violation on top of everything else. And maybe that's more attractive from the court's liberals. With these DVROs, at least the one that was at issue in the Rahimi case, these can be issued ex parte with no counsel. And the idea that you can lose a gun right, lose a constitutional right without even a counsel present, without any process, is bad. But in the Rahimi case, there was no due process issue preserved. They didn't raise due process, and even worse than that, it was litigated as sort of a facial challenge, so you can even consider those other issues. Yeah, what else? Yes.
So we have a common law teacher here who always focuses on this idea in the liberal dissents that, judges aren't historians. And I know that the Kavanaugh response to that is always, well, they're also not policymakers, so that's even worse. But is there any stronger argument other than, the other option is worse for judges doing historical analysis?
Right. So thank you for the question. The question was, it's often said that judges are not historians, and so what's sort of the response to that? I think the response is probably twofold. First, what's the alternative? It is a good argument. Are you just going to make stuff up, whatever you think is fair? Right? It's a lot easier to be a living originalist because you don't have to do anything. Just, guns in our society don't really make sense. Maybe, we don't want guns anymore. The second issue is that the court's been very clear. You don't need to be a historian, right? What does a historian do? A historian tries to tell a story, to tell a narrative about how different groups came together and what social context was like. The task of originalist, I think, is different. It's trying to look at legal meaning. We look at legal meaning in old statutes. We're trained for that. We look at legal meaning in old cases. We are trained for that. We're looking at legal meaning in various common law decisions. We're trained for that. The sorts of things we're looking at are not, vast historical archives to try to create a PhD thesis on, gun culture in 17th century Massachusetts. We're looking at what was the legal system in existence. That's something lawyers are uniquely trained for. Now, I will agree. I think it's a requirement for law students to learn about originalism. If you're not getting a poor education, right? Whether you like it or not, your beloved Florida Supreme Court, your 11th Circuit, these judges care about these things. So rather than sort of complaining ad nauseum about how we can't be historians, actually lean into it and sort of learn the methodology, learn about this history, take classes in legal history, develop it. It'll be much more useful to your associates. So yes, professors can be complaining about it, or they can acknowledge that this is a different state of play. We're not doing numbers anymore. You have to actually develop some chops. That's a good question. I guess one of the.
Do you think that the majority opinion in Rahimi sort of signals that the text history and traditional test for firearms is gone at this point? And do you think there's implications for that in other areas that stand outside of this?
I don't know that Rahimi signals it's gone. What I think it signals is that the justices themselves, they don't agree. And let me just come back to the question that was asked a moment ago. I think it's good that conservative originals don't agree, right? This shows that there's actually intellectual debate going on. We are still figuring this up as we're going along. This is not like, we're the Warren Court. Let's do penumbras. That's great. Oh, penumbras, do abortion. That's just great. We're actually trying to get stuff right. And in Kavanaugh and Gorsuch and Barrett and Thomas, they're working their butts off trying to get things right. They take this seriously. If this was just some sort of ideological ploy, these would be 6-3 cases in every context reaching the same result. Now, as a professor, it's frustrating because I have to teach this stuff. And you got one case in this year and the next case the other year, they're still working the kinks out. To be sure. But I actually see that as a positive facet. So I don't think the text history is dead, but I think they're going to have to be a little more careful to the extent to which they go beyond 1791. I think Barrett's going to demand that. Yes.
Well, I had a question in a similar vein, which was, I think Kavanaugh had a concurrence in, I don't think it was in his Rahimi concurrence. I think it was a different case, but the idea that the tiers of scrutiny, I think it was a case in which tiers of scrutiny were applied, and he said we should never be doing tiers of scrutiny anyways. We should be doing something like text history judicial.
Yes.
So I was wondering about your thoughts generally as to that test applicability in other domains.
Yeah.
First Amendment or any other domain.
Very good. So you take common already?
Yes.
Who here is not taking common? Anyone? Okay, good. You're all taking common. For much of the 20th century, common law focused on what were called the tiers of scrutiny. The tiers of scrutiny. And the way it works is like this. There's certain rights that are really important, called them fundamental. Then there are other rights that are not that important, they're not fundamental. And once you sort of label how important a right is, you decide what kind of scrutiny you review it against. If a right was considered fundamental, well, that's really important. Review any violation of the right with strict scrutiny. That is, you must show the state's compelling interest, really important justification to violate that right. And you show that the law is narrowly tailored to serve that interest. In other words, are you really trying to achieve that interest, or is there some ulterior motive, right? This screen is about smoking out alternate rationales. But if it's just a non-fundamental right, an unimportant right, well, that's not a big deal. We review this with a rational basis standard, which means as long as you have some plausible reason and some interest, that's good enough. The challenge that Justice Kavanaugh and others have identified with the standard is, who the heck is the judge to decide which right's fundamental and which one's not? If it's in the Bill of Rights, the Second Amendment's in there, that suggests it's really important, yet judges still give a basic rational basis scrutiny. If a right enumerated in the Constitution gets a rational basis, this entire system is bankrupt. So in recent years, conservatives have said we need to stop this sort of balancing approach where we just decide which rights are important, which rights are not. We decide, the state has compelling interest, they don't. It's entirely judge-made law. It's judge-made law from top to bottom. At least the history and tradition approach, on paper, is premised on some sort of objective knowledge, something that's outside the scope of the judge's brain. Okay. But I think, just go back to your question, if the court wants to take this seriously, they can't just focus on the Second Amendment. They have to look at the First Amendment. And the First Amendment is an absolute mess of different balancing tests. In Bruin, Justice Thomas said, well, we apply history and tradition in the First Amendment in free speech. Really? Do you? That's new to me. I've been teaching stuff for a long time. So I think what you're seeing then is how to sort of reconcile things across the board. And the court's working it out. Look, it might take a decade, right? I mean, Rome wasn't built in a day. The court's modern free speech doctrine took decades to develop. The court's substantive due process doctrine took decades to develop. And we've only had this, current court for, 4 or 5 years. So they're working on it. And then again, of course, if they expand the court at 25 members, who the hell knows? Everything's off. But just predict where we're going in this direction.
What else we have?
I know it's not controlling, but do we know anything as far as how the founders viewed Second Amendment applied to non-federal entities pre-incorporation doctrine?
Say that again. I lost the thread of the question.
Like pre-incorporation doctrine, do we know anything as far as how the founding generation viewed the Second Amendment as how it would apply to states? Like, were there states that had Second Amendment protections in their
Oh, I see what you're saying. Right. So even though the federal Constitution has a Second Amendment with this militia language, the states also have similar guarantees without the militia language. And the Second Amendment guarantees the states were, I think, pretty robust. And there actually were a number of cases from states guaranteeing rights to bear arms to carry and the like. So I think Justice Thomas and Justice Scalia and Heller looked to those state common law provisions to inform the meaning of the Second Amendment, saying this was an analog. Leading up to the ratification of the 14th Amendment, it was often discussed that the right to bear arms was a privilege or immunity of citizenship. This was Justice Thomas's McDonald's opinion. I think this is a very strong argument. I mean, we could talk about Dred Scott for a moment if you want. The issue in Dred Scott v. Sanford was Dred Scott a citizen, right? And as you probably know, under the original Constitution, if you were a citizen, you were guaranteed certain rights called privileges and immunities. It's in Article 4 of the Constitution. And Chief Justice Taney said, wait a minute. If Dred Scott's a citizen, then he gets these privileges and immunities. And one of these privileges is the right to bear arms. It cannot be that a black person can have this right to bear arms. Therefore, he's not a citizen. You got it backwards. It's because he was a citizen that he had these rights. So I think it's actually a very good historical argument. A very good historical argument that the Second Amendment becomes even stronger on incorporation than it was in 1791, right? The right to bear arms in Reconstruction was a lot more important. People were fighting off the Klan and lynch mobs. This was an important right that was deemed fundamental, I think even more so than we had in the times of revolution. Good question. What else? Yes.
Do you have any thoughts on how, I know there's been a lot of debate on what the tradition called text history tradition means. Do you have any idea or any sort of dog in that fight about how you think that should be viewed?
So I'll say the 11th Circuit, Judge Newsom, who's in Birmingham, she's going there in 2 weeks. Judge Newsom has explained that, okay, I get text, right? We have to look at the text, what the words are. I get history. That is what history informs that text. Newsom's like, I don't get tradition. He's like, why are we looking at stuff that happened after ratification? And this is the debate that Barrett and Kavanaugh are having. My dog in the fight is we just don't look at tradition. I look at text and history. We don't need tradition. Tradition lets you deviate from the text and history. The fact is, if the government did something after the text was ratified, that is not evidence of what the text actually meant. I think using tradition lets you keep in place a lot of perhaps very dubious regimes that existed without meaningful judicial scrutiny. So I would give tradition very lightweight, but Justice Kavanaugh just, he watched Fiddler on the Roof too many times. He loves tradition. Thank you. What else? Going once. Going twice. Thank you all so much.
Thank you, everybody, for taking time out of your afternoon to come. We'll see you all next semester.
Is your last event this semester?